Good morning. All right, it's a little 10, so we're going to get started. My name is Ken Hill. I'm Senior Associate General Counsel at PERAC. Along with me today is fellow Senior Associate General Counsel, Patrick Charles, and we're going to be presenting. Patrick and I have noticed that we're given a slot here for 3 hours. Rest assured, we will not be going 3 hours. This is our cases of interest presentation. This has never been done before with these cases, so bear with us. Historically, these have, we look for cases that are somewhat unusual. Sometimes it's a scenario that you'll never see, but we just found it interesting, so we want to include it. But oftentimes it's something that might pop up, and we want you to be aware of it. So having said that, I will begin. The first case that I would like to discuss is the matter of OLeary versus Crabb, the Lexington Retirement Board, and PERAC. This is a very recent, September 26, 2019, Superior Court decision. Before I jump into that Superior Court decision, though, I need to give you some background on this case. First of all, this is a very important case. It has potential to have a far-reaching impact. And what it's about is oftentimes collective bargaining agreements have provisions in them wherein employees may sell back unused vacation days. Okay. The issue in this matter is whether the compensation that they for selling back those vacation days constitutes regular compensation and should be used in a retirement calculation. Now, Chapter 32, Section 1 and 840 CMR 15.03 define the term regular compensation. Okay. And regular compensation is what someone's retirement allowance is based upon. Okay. If we back up a little bit and go back to 2012, PERAC issued memo number 39 of 2012. Okay. And that memo provides an analysis that retirement boards must perform to determine whether vacation buyback compensation constitutes regular comp. There are two threshold requirements. Okay. The board must find that the pay is part of the base compensation or other base compensation, and the payments must be for services performed for the employer. If those threshold requirements are met, then there are 10 additional factors that a board must look at. Those other factors include whether or not the payment was a one-time payment, whether it was made primarily in the last 3 years to augment someone's retirement allowance, and whether or not the participant did it consistently, things like that. Well, that brings us to Mr. OLeary. Mr. OLeary was a police captain in the Lexington Police Department. Starting in 2008, as soon as he was eligible, he exercised a provision in his CBA and sold back 2 weeks of unused vacation time. He exercised that option for 7 years in a row. As he approached his retirement time, he approached his board, the Lexington Retirement Board, and inquired whether the compensation he received for selling back that vacation time was regular compensation. The Lexington Retirement Board did not perform the analysis laid out in PERAC memo number 39 of 2012 and told him that it was not regular compensation. Mr. OLeary appealed that decision to DALA, and PERAC was added as a necessary party. The DALA magistrate found that the vacation buyback payments were not regular compensation. He found that they had to be elected every year, so they were of limited duration. He also found that they were akin to overtime, and the person was essentially being paid double time for 10 days. He further found that it was a salary enhancement designed to boost his retirement allowance. The magistrate did find that the Lexington Retirement Board was required to follow PERAC memoranda. And the magistrate did not say that such payments can never be regular compensation. Well, following that decision, both Mr. OLeary and PERAC appealed to Crabb. Crabb determined that such payments can never constitute regular compensation and invalidated PERAC's memo. Crabb found that the payments were not base compensation, they were not for services performed for one's employer, they were not predetermined and non-discretionary, and that they were in the nature of a salary augmentation plan or overtime. Well, Mr. OLeary and PERAC appealed that to the Superior Court, which brings us to the decision that just came out about a month and a half ago. Actually, before I get to that, after the Crabb decision, but before the Superior Court decision, PERAC filed a motion for stay regarding the implementation of Crabb's decision. We were concerned that boards would have to do recalculations on retirees, and we wanted to stay that until final judicial review. Crabb granted a partial stay, and the partial stay said as to retirees that it was entirely stayed. No recalculations should be done pending completion of judicial review. However, it was only partial, so they found that active members, no further contribution should be taken for vacation buyback pay, but no refund should be given for prior contributions yet. For pre-retirement inactives, Crabb determined no refunds yet. For future retirees, Crabb determined the calculation of shall not include payments for unused vacation pay. And for Mr. OLeary himself, Crabb determined that his calculation was done without including the vacation buybacks, and it should remain that way. Now it brings us to the Superior Court decision of September of 2019, wherein Superior Court Justice affirmed Crabb's decision that payments for unused vacation time are not regular compensation. Mr. OLeary has already filed a notice of appeals to the Court of Appeals. PERAC intends to do that this week. So this matter will continue, and there has not been final judicial review. The partial stay remains in place. Although, as I said, we're going to file with the Court of Appeals, we're also aware that there are several entities that are looking at filing special legislation regarding this vacation buyback policy. So this matter is still in flux, and we will keep you updated. The next case I would like to discuss is the case of Bissell v. Springfield Retirement Board. This was a decision, a DALA decision that came out in May of 2019. Factually, this matter involves a firefighter, Mr. Bissell, who in 2012 was injured in a gas explosion. He and fellow firefighters all sustained injuries. Mr. Bissell sustained injuries to his hand, his ears, and his head, including a concussion. Following that explosion, Mr. Bissell developed certain cognitive issues. He suffered from depression, anxiety, and PTSD related to the gas explosion. He continued to work, but his condition worsened over time. And eventually, his employer filed an involuntary accidental disability retirement for him due to his PTSD related to the explosion. And accidental disability retirement was granted to Mr. Bissell for the PTSD. Meanwhile, Mr. Bissell filed a lawsuit against the gas company. He settled with the gas company for $155,000. That brings us to Chapter 32, Section 14A. This is a little-known statute, okay, or section of the statute, that provides for third-party recovery matters. Okay? And what it says is that if a member who retires due to a disability also has a right to recover lost wages from any party by reason of the same injury, the amount of any such recovery for lost wages shall be offset against and payable in lieu of any pension payable. So 14A allows a retirement board to offset a third-party recovery. However, Mr. Bissell did not notify the retirement board of his settlement agreement. There were 3 other firefighters who were injured in this blast who retired for accidental disability for PTSD as well. All 3 of them notified the board, and pursuant to Section 14A, their recovery was offset. The board collected about 30% of their gross settlement with the gas company. Those firefighters agreed to it. When the board found out about Mr. Bissell's settlement, they sought approximately 32% of offset pursuant to Section 14A. Mr. Bissell appealed that decision. He did not think that they were entitled to any offset. He really didn't have much of an argument at Dalla, however, and Dalla magistrate found that the offset amount of 32% was appropriate and ordered it. The Springfield Retirement Board discussed with Mr. Bissell about paying for the offset and agreed that they would take $500 a month from his monthly retirement allowance in order to pay off the approximately $50,000 that he owed. Oh, actually, it was less than that, I'm sorry. But they were going to take $500 a month. And then in the agreement with Mr. Bissell, they said that from time to time they would review that figure. Recently, the Springfield Retirement Board notified Mr. Bissell that they needed to increase that amount from $500 to $1,000. Mr. Bissell was outspoken in his opposition to this. PERAC was, I'll say, informally consulted on the matter. And if you look at Section 14A, it requires the actuary of the Commonwealth to approve a schedule of repayment, such as the one going on. And informally, the actuary said, if I was going to make up this schedule, it would be more than $1,000 a month. Okay, so we gave that informal opinion to the Springfield Retirement Board, and I believe that they have discussed it with Mr. Bissell, and there is a higher than $500 but less than $1,000 payment going on. And we wish Mr. Bissell all the best. The next case.
Would it be a good idea for me to be trying?
Just a reminder, if everyone could please mute their phones. We'll be taking questions. You can type up questions to us, and we'll try to address them when we are complete with this. Thank you. The next case is Turalyan v. Hampden County Retirement Board. This is a Dalla case from March of earlier this year. Mr. Turalyan was a full-time building inspector for the town of Wilbraham, which is a member of Hampden County Retirement Board system, I should say. In 2007, he became the part-time building inspector for the town of Hampton, which obviously is a part of the Hampden County Retirement System. In this part-time position as a building inspector, Mr. Turalyan received compensation by way of, he got 80% of the cost of each permit that he did as an inspection. Now, the number of permits and the amount he earned varied month to month. Obviously, if he did a lot of permits, he would make more. In 2016, he requested information from the Hampden County Retirement Board regarding his retirement allowance. And the board calculated his retirement allowance based upon his full-time service in Wilbraham. And then they inquired to PERAC of whether they should also include the money he received as the part-time building inspector for Hampden. Now, as I said earlier, regular compensation is defined in Chapter 32, Section 1, and 840 CMR 15.03. In part, in order to be regular compensation, payments must be regular, recurring, predetermined, and guaranteed. Now, PERAC informed the board that the payments based on 80% of the permit fees was not regular compensation because it was not regular, predetermined, or guaranteed. Indeed, it varied tremendously every. Mr. Turalyan appealed that matter to Dalla, where the magistrate agreed with PERAC's conclusion. Now, this case is in line with several other cases that we've come across. I recall a case involving a wire inspector that was paid similarly. And there was a case where a sheriff received a percentage of the cost of process serving. And those were found to be not regular compensation either. Because things like that are just, as I've said, they're not regular, predetermined, or guaranteed. So they cannot be regular compensation, and they cannot be utilized in determining someone's retirement allowance. The next case is Lensky versus the Teachers Retirement System. This was a Dalla decision from March of 2019. This matter has been appealed, and it's currently pending before CRAB. But factually, Ms. Lensky was a special education and grade school teacher. The physical requirements of her job did include bending, squatting, kneeling, and some light lifting. Okay. One day, while she was walking down the hallway at the school where she worked, she slipped in a puddle that was near the water fountain in the hallway. She claimed to have sustained an injury to her shoulder, and she was diagnosed with partial thickness tear of the rotator cuff. She complained of pain. She went through physical therapy. She received some injections. Nothing seemed to work. Surgery was recommended, and in July of 2014, she underwent shoulder surgery. Following surgery, she continued to complain of pain and limited range of motion. She was treated again conservatively, more physical therapy, more injections. Nothing seemed to work. And she claimed her shoulder pain was too intense and that she could not work. So she applied for accidental disability retirement. She was examined by the medical panel. One doctor determined her permanently disabled and stated that additional treatment would not help. A second doctor determined she was permanently disabled. A third doctor said surgery could help, but if she didn't go through with the surgery, it was likely permanent. The board then denied her application because saying that she had failed to prove that her injuries were permanent. Okay? And Ms. Lensky appealed that to DALA. Now, the board essentially determined if she underwent this surgery, she wouldn't be disabled. Okay? And a public employee can be denied accidental disability retirement benefits if she, quote, unreasonably refused standard or routine medical treatment that is not so inherently dangerous and that would probably effect a cure by rendering a disability temporary. All right. The issue is whether her refusal to undergo this second surgery was unreasonable and unreasonably refused. Now, the magistrate found that given that she underwent the surgery already with no significant relief, it cannot be said that her refusal to decline a second surgery was unreasonable. The magistrate noted that especially when there existed a possibility that her condition could worsen, which was something that one of the doctors had noted. So we see matters like this fairly routinely, where if a person undergoes a second surgery or a serious surgery, like a spinal surgery, the doctors say it would improve their condition. But a lot of those surgeries, especially the spinal ones, carry significant risks. So the unreasonable standard is pretty high. But Ms. Lensky, as I said, was found her refusal was not unreasonable. But as I also noted, this matter is under appeal to CRAB. We'll try to keep you posted on this. The next case is Marathis v. Dukes County Retirement System. This is a decision from over a year ago, September of 2018, but we found it interesting. So Officer Marathis was a police officer in the Tisbury Police Department, which is part of Dukes County Retirement System. In 2007, while he was on duty, he injured his back trying to stop a vehicle that the emergency brake had gone off and it was rolling down a hill. He injured his back and he was out of work several months, and he collected 111F during this time. And he returned to work. About 4 years later, he re-injured his back while on duty. He was trying to clear debris at a crash site and injured his back again. And he was out of work for several months, and he collected 111F again. And then he returned to work without incident. In July of 2014, he resigned from the Tisbury Police Department and joined the Oak Bluffs Police Department. And before he joined, he passed a fitness for duty test, and he was given a 1-year probationary period. The Oak Bluffs Police Department requires its police officers to maintain a high level of physical fitness, and it encouraged its police officers to use a gym that was actually located in the police station. In August of 2014, soon after, just 1 month after he joined the police force, he re-injured his lower back while exercising in the station gym. Despite the pain, he actually went out on his assigned shift with another officer. While out on that shift, there was a fight that broke out, and the police officers went to go break it up. And as Officer Marathis attempted to intervene, his back seized up and he actually collapsed. He eventually went to the emergency room, and an MRI showed that he had degenerative disc disease. He filed an injury report and eventually was actually granted 111F benefits. He returned to work for a few months, but the pain was too great for him. He was placed on administrative leave, and while on leave, his employment was actually terminated. He was still in that probationary period. The chief noted as part of his termination that he was dishonest and that he had misled the police department because he failed to disclose that he had 2 long-term injuries prior to joining the police force, and that he had become a scheduling burden and he called out sick frequently because of his back. Now, after he was terminated, he actually sought employment with the Edgartown Police Department, but he did not get a job. After seeking that employment, he filed for accidental disability in February of 2016. In his application, he noted 3 injuries. The first was in 2007 when he jumped into that vehicle to try to stop it. The second was in 2011 when he was injured picking up that material at the crash site. And then the third one was in 2014 when he was working out in the gym. He received a unanimous positive medical panel. Okay? They found for disability, permanence, and causation. The board denied his application, however. Mr. Marathis appealed to DALA. DALA determined that he failed to demonstrate that his injury occurred, quote, while in the performance of his duties. They further noted that he failed to prove that he sustained a total and permanent disabling injury while in the performance of his duties. The magistrate noted that he was cleared for police work in June of 2014 and that he had been able to work after those first 2 back incidents. Okay? And that the August 2014 injury occurred while he was working out, and that was not in the performance of his job duties. The fact that he may have been carrying out department orders to remain physically conditioned does not mean that he was in the performance of his duties. And they noted that employers in modern times routinely expect employees to try and remain in optimum health. The magistrate further noted that his decision to go out on duty after injuring his back further complicated his injury, and his lack of seeking treatment, likely made the injury even worse. They noted that he was in a position to mitigate his injury, but he chose not to, and he bears responsibility for it. And that is a final decision of DALA. We see a lot of cases that hinge on the issue of whether or not someone was in the performance of their duties. And it occupies a lot of our time, I'll just put it that way. The next case I would like to discuss is Gambali versus Essex Regional Retirement Board and PERAC. So it's a decision from May of 2019. Mr. Gambali retired for accidental disability retirement in 1990. Okay. Now, pursuant to Section 91A, disability retirees must file an annual statement of earned income. And pursuant to the statute, failure to file this form can result in the termination of one's retirement allowance. Termination, not suspension. In 2014, PERAC notified the Essex Retirement Board that Mr. Gambali failed to file his annual statement and that the board should notify him in writing and give him an opportunity to be heard. The board did this. Mr. Gambali, however, did not respond to the board, and in August of 2014, the board stopped paying him his retirement allowance. Several months later, the board again notified him. Okay? Following this notification, he did file his annual statement, and he gave PERAC good cause for his failure to file it. Mr. Gambali asked for the money that he would have received during this period back because he said he had good cause for it. The board said, no, we terminated your benefit and we could not give you that money until you complied with the statute. He appealed that to Dalla. The Dalla magistrate said, unfortunately, Section 91 is specific in calling for termination of your benefit. Okay. The magistrate noted that although this may seem like a harsh result, the language of the statute is clear, and that the legislature has taken an increasingly aggressive approach to members who fail to file their annual statements. So if your benefit is terminated under 91A, it's important for your members to know that there's no retroactive payment given to you. This is not a suspension, okay? It is a termination, and it is very important for members to file their 91A annual statements. We've been asked, and unfortunately I don't know the answer to this, what happens to health insurance if their benefit gets terminated during this time? And I would say that they run a very real risk that their health insurance could be terminated because their benefit is terminated. And then I don't know if they would run a more significant risk of their insurer possibly not letting them back on. So the moral of the story is make sure your members know the importance of filing their annual statement of earned income. The next case is Rodricks versus PERAC. This was a Superior Court decision from January of earlier this year. Now, factually, go back to 2010. Okay, Mr. Rodricks was a firefighter, and he was involuntarily retired due to a congenital heart condition. In 2015, he applied for return to service under Section 8. He was examined by a medical panel. Okay. A RTS medical panel needs to be unanimous in its decision of whether or not someone can return to service. 2 of the doctors found him unable to return to work. One doctor found it due to his heart condition, and another one found it due to his hearing. Now, as it regards hearing, there are standards that are promulgated by the Human Resources Division of the Commonwealth. And for public safety officers, they must pass certain threshold requirements. And those thresholds are noted in HRD's initial hiring provisions. Mr. Rodricks disagreed with this and he appealed to Dalla, okay, where the matter remains pending, as a matter of fact. At the same time, he filed this present lawsuit in Superior Court. He essentially alleged that PERAC's use of HRD's initial standards constituted age discrimination because they should be adjusted. Okay? They are the initial hiring standards. However, HRD does not have any age-adjusted standards for PERAC to follow. And PERAC argued that. PERAC filed motions for summary judgment. They were eventually granted. The judge determined that the fitness to return to duty can only be made by a medical panel. The judge found that the judge had no authority to determine whether someone was fit for duty, and PERAC had no authority to determine whether someone was fit to duty. They also found that PERAC has no discretion as it regards HID standards. Those are the only standards we have, and that's what we must apply. They further found that PERAC was immunized from liability because it was acting pursuant to law, in this case, Section 8 of Chapter 32. And finally, they summed it up by saying that PERAC cannot and did not discriminate based on Mr. Rodricks' age. Now, subsequent to this, Mr. Rodricks applied for return to service again. There's been another hearing issue, and there has been another lawsuit filed in this matter. So, although it's not the same lawsuit, because it's based on a different return to service process. It's back in Superior Court, and we'll try to keep you abreast of this case. The next case is the Cambridge Retirement Board versus PERAC. This was a dollar decision from February of 2019. This involves Section 12(2)D. It's a beneficiary issue. As many of you know, Section 12(2)D concerns the death of a member in service. Now, as it regards this case, in 2006, Robert Lucas, who's a member of the Cambridge Retirement System, filled out his Section 12(2)D beneficiary form. And that 12(2)D provides a member survivor allowance for a beneficiary for life. Mr. Lucas wrote in the name of his daughter on the form as his 12(2)D beneficiary. He also wrote in the name of his son along the margin of the form. PARAC has long maintained that Section 12(2)D permits the naming of only one beneficiary. The Cambridge Retirement Board, however, looked at his form and determined that he wanted it to be split amongst his daughter and his son. PARAC again said you cannot do that, and the Cambridge Retirement Board appealed to DALA. The Boston Retirement Board apparently has also believed that you can split the 12(2)D benefit, and they intervened in the matter to give the DALA magistrate their opinion on the matter. The DALA magistrate determined that Section 12(2)D permits only one beneficiary, and that the fact that the daughter's name was in the correct place on the form led the magistrate to assume that she was the choice. Now, personally, I can totally understand if there's no spouse involved in a situation and you have two children, how do you choose? It's quite the Sophie's choice in a lot of ways. I actually thought about it on my own self, and I have a spouse, but if I didn't, I have two daughters. And which one would I choose to get this benefit? I mean, one has more common sense, but the other's nicer, so I'm not really sure which one I'd go with. I'm honestly flip-flopping on it in my head as I speak. I think I'd go with the nicer one because she would share it. The one with common sense is a little more evil. You know? I'm not sure she'd help out her sister. But anyway, that's my personal battle. The next two cases are similar, and they both involve Section 91A. Okay. The first is the case Rome versus Middlesex County Retirement Board. This is a CRAB decision from May of 2019. Section 91A limits the amount of earnings someone retired for disability may earn. Earnings includes any work that involves, quote, some labor, management, or supervision. Now, with that as a global offering, Mr. Rome was a police officer. He retired for accidental disability retirement in 1999. He owned a few businesses, okay, some bars. They weren't incorporated. They were subchapter S corporations. He had limited involvement in the operations of the businesses, however. He testified that he did maybe 100 hours of work a year for both of the businesses. He argued he was just passive ownership. He did testify that he participated as to decisions regarding the distribution of profits and other matters. He did some bookkeeping for the companies. But again, he said, I don't do much. I'm not working. This is just passive. CRAB disagreed. They have found that even though he had this limited involvement, it still included, quote, some labor, management, or supervision. Mr. Rome also argued that he did not earn anything, okay? Because apparently an S corporation is not required to distribute the profits it earns to its owners. It can remain within the business. Any profits can be used as write-offs or business expenses or business investments. So he argued, I did not get any money. Okay, the business got it all. Crabb said, no, you earned it. It doesn't matter how you afford things on your federal tax form. Crabb agreed with PERAC's interpretation. The earnings include the profits of a business, regardless of the categorization of such profits for purposes of taxation or other purposes. So here they found, even though he had limited involvement, it was some labor management or supervision, and even though he did not personally get any money from the business still had earnings, and he is an owner of the business. So he was responsible for those earnings under 91A. And as I said, the next case is similar. It's West Springfield Retirement Board versus PERAC and Deneen. It also is a Crabb decision from May of 2019. It's another Section 91A case. In this scenario, Mr. Rome was a police officer who retired for accidental disability in 2009. Even prior to retiring, however, he co-owned several businesses. He was named the president of some of those businesses. He signed the liquor licenses and applications and the tax returns for those businesses, but he claimed that was it for his involvement. He did not do anything else with the day-to-day operations of the business, he testified to, claiming to be a passive investor. Okay? And there was no evidence that he played a substantial and active role in the business. Crabb determined, though, that even the acts of being named president and signing those forms was enough to constitute evidence of some labor, management, or supervision. And so he was beholden to the monetary restrictions of Section 91A. And this was a final decision of Crabb. I believe that is my last slide. Yes, it is. As I said, we'll be taking questions at the end. But right now, I think we'll take about a 5-10 minute break. Say a 10-minute break, and we'll come back on, and Patrick Charles will present. Thank you.
Okay, good morning. This is Patrick Charles, Senior Associate General Counsel. And as with the same with Ken, I'm going to be doing about 10 cases today. A couple of them I'm going to combine into basically one presentation, but there will be 10. I do want to add a disclaimer right at the beginning. You're going to notice that about half of my 10 cases all involve the State Retirement Board. This is simply a function of the fact that the state and the Teachers Retirement Board are the two biggest systems. And frankly, there's just a lot more Dalla and Crabb cases out there for us to review that involve them than all the other boards. And so that you're going to see they encounter a lot of unique situations and a lot of cases that don't go through and don't come up in some of the other boards on a regular basis. So they're very instructive for this presentation and for all the boards to understand how they handle cases and how Dalla has ruled on them. The first case I want to talk about is Dargy versus the Massachusetts Teachers Retirement System. This case, I really like this type of case. Usually when I first look at a case and I see that it's a wrongful termination or that wrongful termination was involved, I usually really like those because there's always some good factual information, some really good story as to why the person was terminated, some sort of conflict at work or termination. Unfortunately, this case has none of that. Because really the case has nothing to do necessarily with the fact that she was wrongfully terminated. She was, but the case is not about the termination itself, but about how to calculate the settlement agreement and what contributions she needs to pay for creditable service for the time that she was wrongfully terminated. So Ms. Dargy is a member of the MTRS, and she began working as a guidance counselor in the Southbridge Public Schools in 1993. On December 10th, 2013, she was fired by the superintendent of schools. Now, she went to her union and filed a grievance, and she went through the full grievance procedure process, and it went all the way to arbitration. And at the end of August of 2014, About 8 months after she had been terminated, the arbitrator ruled in her favor and determined that she was entitled to be reinstated, and she was to be made whole for all of her losses, including back pay and any other relief to which she was entitled under Chapter 71, which is the education statute. Under the arbitrator's award, Ms. Dargy was due the salary that she would have been paid from December 13, 2013, through the end of the school year on June 30, 2014, as if she had not been terminated. This equaled about $45,000. Now, from that total was subtracted any unemployment she had received, and she had, in fact, collected unemployment for the 6 months she was off in the amount of $19,000, which left approximately $26,000 to be awarded as back pay. On March 26, 2015, so she was, in fact, reinstated for the start of the 2014-15 school year. And in March of 2015, some 6 months after she went back to work, the teacher's retirement system informed Ms. Dargy that she could purchase the 6 months of creditable service, a little bit over 6 months, for the period from December 13th until June 30th. They calculated the amount that she would owe, representing the contribution she should have paid into the system had she been employed for that 6 months, as just over $4,000. This was actually calculated based on the contract rate for her position. The contract rate for the 13-14 school year for a guidance counselor was $73,000. They used this amount because they did not have a record of any sort of the exact amount that she actually received when she went back to work, what back pay she was actually given. So they used the reasonable rate of whatever she should have been paid per her contract had she been employed, and subtracting out what she actually had been paid for the first 4 months of the year. So Ms. Dargy was given an invoice, a bill for the amount of $4,000, but she did not pay the invoice. So a few more months went by, and the board notified her in August of 2015 that they were only giving her creditable service from September through December for the 13-14 school year, and that she would have a break in service because she had not paid the invoice. The only way for her to get the full year's creditable service would be for her to pay the invoice and pay back what she should have contributed had she been in service that entire 6-month period. She appealed this case to DALA because she did not believe that the calculation of the $4,000 was accurate. She believed that her buyback should be calculated not based on what she would have been paid, but rather based on the settlement amount that she was in fact paid as back pay for the time she was out. It appears that after the arbitrator's award, which again was $25,000, almost $26,000 of back pay once you subtract out the unemployment benefits, for some reason there was a settlement between the school system and Ms. Dargy, and she was only actually paid $15,000 in back pay. Unfortunately, there was no written agreement of the settlement, and both the school and Ms. Dargy claimed that there was in fact no written agreement which stated the actual $15,000 amount, though she did have record of that was basically the check that she received from the town. So she claimed that she should only have to pay back on this $15,000, and she was an 8%er because of being hired in 1993, so she would have been paying 8 plus 2 on that amount, which would be substantially lower than the 8 plus 2 on the full award. Now, teachers who are terminated from their positions are by law entitled to pursue wrongful termination claims, and if successful, they can claim reinstatement and back pay. The awards may incorporate creditable service with the accompanying retirement contributions that should have been paid had the member stayed in their position, and this is to restore the employee to the same position they would have been in had they not been wrongfully terminated. Similarly, parties can agree through settlement agreements to award back pay and creditable service so long as the award is proportional. That is, the amount of creditable service is proportional to the amount of back pay awarded. So for instance, if you should have been paid $100,000 for a year of service and they give you a back pay award of $50,000, you can't get a full year's creditable service based on that $50,000 because that's only half what you would have gotten paid. Proportionally, it would be a 6-month creditable service amount. Settlement agreements attempting to award credible service are lawful only if they fall within the bounds of what Chapter 32 allows. In some cases, members have tried to gain credible service where no back pay was awarded and no retirement deductions were paid, but they were unsuccessful. They have lost those cases at the board level and at Dowling and Crabb. If a person settles for less than what they would have been paid, then their credible service is also proportional to the back pay amount. Now, in this case, there is apparently a settlement agreement for less than her actual amount. However, that settlement agreement was never put in writing, and therefore the retirement board could not rely upon it. And since there was no settlement agreement, the retirement board decided to use the arbitration award, which gave full credible service and full pay. Now, PERAC has issued memoranda on this subject in the past. Most importantly for this case is PERAC Memo 28 of 2001, which details how a board should review settlement agreements and what steps need to be taken when a member may be entitled to credible service and back pay. A board must determine the exact period of time covered by the award of settlement, the amount of the regular compensation the member would have received, and the amount of contributions that would have been made had the member not been terminated. Once those factors are known, they can calculate the amount of buyback, the buyback payment amount that the member would be responsible for in order to get the credible service for the period covered by the settlement agreement or by the arbitration or court award. And in this case, Dalla held that the calculation that the MTRS used was correct, and the member must pay the amount of contributions that would have been paid had she not been terminated if she wishes to receive the full credible service for the 2013-2014 school year. The next case is a state case. This is Moran versus State Retirement Board. Mr. Moran was employed at the Department of Mental Retardation in November of 1988, and he retired in 2001 with 12 years of service. He receives a modest retirement allowance. By calendar year 2016, his monthly allowance was only $651 a month, or about $8,200 per year. In January of 2016, looking to supplement his income, he took a job as an aide or a teaching assistant at the Lower Pioneer Valley Educational Collaborative. He was working for approximately 32.5 hours per week for the school year. He didn't work during the summer or during any school vacation periods, but the 32.5 hours for the school year would in fact exceed the 960 hours per year that a member can work under Section 91, Paragraph B. When he was hired at the Lower Pioneer Valley School, they attempted to enroll him in the state retirement system. They were not aware that he was already a retiree from another institution, so they tried to make him contribute, and they sent contributions to the state board. The state discovered this error, that they were getting contributions for one of their retirees, and they notified the school to stop the contribution. They then returned all the contributions that were taken in error and notified Mr. Moran by letter in August of 2016, so about 8 months after he had joined the system or joined the Lower Pioneer Valley School. They informed him that he was not able to contribute, that as a retiree, he was subject to both hours and earnings limitations under Section 91B. So a couple months later, he's coming up against his 960 hours, though he is not up against his earnings limit in terms of dollar amount. But as he approached the 960-hour limit in October of 2016, he wrote a letter to the board and requested that his allowance be waived pursuant to Chapter 32, Section 90B. Section 90B provides that a member, a retiree, can waive the receipt of their retirement allowance for a specified period or until such time as they notify the board that they wish to resume their retirement allowance. So a person simply needs to send a letter to the retirement board saying that they are waiving it. They can waive it for a 6-month period, or they can say, I waive it until further notice, and their benefit can then be reinstated once they notify the board that they want the benefit to be reinstated at a future date. On January 8th of 2017, So he has waived his retirement allowance for the end of 2016 to avoid, because he would not be subject to the hours and earnings restriction if he was not receiving his retirement allowance. So often we see waivers where someone is taking a full-time job after being a retiree. They often will waive their allowance for the entire year because they know that they will over-earn either in hours or in both hours and earnings. But in January 8th of 2017, he wrote a letter to the board saying that he now wanted his retirement allowance to be reinstated. He did not inform the board that he was still working at the Lower Pioneer Valley Education Collaborative, and they didn't know because obviously he wasn't sending in contributions anymore, and so they didn't really have any way of tracking his employment status. So his allowance was reinstated effective in January, though he did not receive his first check until March of 2017. In the January 11th letter in 2017 from the board that informed him that his benefit was being reinstated, they reiterated that a 90B waiver could not be used annually and that he was subject to hours and earnings restrictions. In October of 2017, Mr. Moran requested a waiver of his retirement allowance again. Apparently, according to the Dowler record, Mr. Moran believed that waiving his retirement allowance every single year when he reached the hours limit was a good way and a perfectly valid way to avoid over-earnings. In January of 2018, the board rejected the second waiver, and they explained that 90B waivers could not be used to avoid hours and earnings restrictions. Mr. Moran filed the appeal to Dowler in February of 2018, and according to the record, he exceeded the hours limit in 2016, 17, and 18, but at no time did he exceed the actual earnings dollar limit in any of those years. Most likely, this is because his pension was so low and he had a fairly high earnings capacity because his pension was so much lower than his previous position. Because if you'll remember, he retired with only 12 years of service, so he was nowhere near an 80% retiree. It wasn't established exactly how old he was when he retired, but he couldn't have had a very high percent. The first thing to remember about this case and any other cases similar to this, or any cases where you have post-retirees that are in fact working and earning, is that earnings restrictions have both an hour and a dollar limit. They are not exclusive of each other. They are both limits. So if you hit one or the other, you must stop working. Mr. Moran did not understand the fact that because he was so far under the earnings limit, the hours limit were what was going to cause him to be an over-earner, and that if he worked in excess of 960, any money he earned from any hours over 960, regardless of whether he was at the earnings limit, would have to be repaid because he was no longer legally available or able to work under Section 91, Paragraph B. The issue of the year-to-year waivers was addressed originally over 30 years ago, or 40 years ago in 1979 by the Attorney General in an opinion of the Attorney General. And they stated at that time that a waiver from year to year would defeat the purpose of the hours and earnings restrictions imposed by the legislature in Section 91B. Now, in this case, Dowler ruled that the state was correct to deny his waiver and correct that he was an over-earner because he had exceeded the 960 hours. However, the matter was actually remanded back to the State Retirement Board to determine how much he over-earned, because that was not actually part of the record in the case. There was just an acknowledgement that he had worked over 960, but not by how much. So this matter is pending before the State Board, I believe, for them to calculate the earnings amount that he is over. This next case is Jump versus State Retirement Board. And this deals with the option C beneficiary and what happens when life situations change for a member after they've retired and already named their beneficiaries. In this case, Beverly Jump sought to collect the option C benefit as the surviving ex-spouse of Robert Jump, and the state denied her her right to that benefit, and this appeal followed. Robert Jump worked at the Tewksbury State Hospital prior to his retirement for superannuation on July 19, 1997. At the time of his retirement, Robert and Beverly were married, and Robert chose option C and named Beverly as his option C beneficiary. Unfortunately for the Jumps, life situation changed and they got divorced in 2002. They entered into a separation agreement which was incorporated but not merged into their judgment of divorce. And in the separation agreement, both Robert and Beverly agreed to waive any and all rights to any pension or retirement funds held by either party. There's nothing in the record about whether Beverly had any retirement funds or benefits. There's nothing about whether she, in fact, was a public employee entitled to a Chapter 32 pension in any way. The only thing in the record is this settlement agreement, which does not reference specific retirement accounts. It simply has generic language regarding any retirement fund or any pension either party is eligible for. Their divorce was finalized in August of 2002. And at the time of the divorce being finalized, Robert went to the State Retirement Board and filled out a change of beneficiary form with the board and named his daughter as his beneficiary. This wasn't a new option selection form at this point. This was simply a change in beneficiary form, which would have impacted only such a thing as the final payment of a retirement allowance. In the event of Mr. Jump's death, the final month's payment, the partial payment that he might have been entitled to, would have been paid to the daughter as the beneficiary under this change of beneficiary form. About a few days later, he did in fact go back to the retirement board and got a new option selection form. And he attempted to change his option from C to A. The board denied Mr. Jump's change in option, informing him that once a retirement option is selected and a member is retired, then the option selection may not be changed. Now, this is true for option C. Once an option C beneficiary is named, it cannot be changed. But as we'll talk about in a minute, option B beneficiaries can in fact be changed after retirement. He filed a motion in the Middlesex Probate and Family Court and asked the court to order the board to allow a switch to option A based upon their divorce agreement, the fact that they were divorced, and their divorce agreement. On November 24, 2003, the Family Court, Probate and Family Court, actually did issue such an order. And Mr. Jump notified the board in July of 2004 of the order and provided them with it. But the state informed Mr. Jump that a change in option was not permitted under Chapter 32, and therefore they would not change his option even though he had a court order. Mr. Jump appealed this determination to DALA. Again, this is all the way back in 2004. And in November of 2005, DALA issued a decision in that aspect of the case on whether or not the board should change his option C beneficiary because of the court order. But DALA affirmed the board's decision on the grounds that Chapter 32 is controlling and that law does not allow a change in option for option C recipients. The DALA case was decided in 2005. So you may be asking yourself, why is there another Jump case in a 2019 presentation? Well, if you remember, the board didn't allow Mr. Jump to change his option, and they didn't allow him to change his beneficiary, so Beverly Jump was still listed as the option C beneficiary. Mr. Jump died on July 13th of 2017, and Beverly went to the board and said, I'm the option C beneficiary. I want to be paid the option C survivor allowance. And December 12th of 2017, the board denied Beverly Jump the survivor benefits on the grounds that she had waived her right to Mr. Jump's pension in her separation agreement, which was signed in connection with their divorce all the way back in 2002. So when the board was opposing Mr. Jump's change in option, they apparently also realized at that time probably that Mrs. Jump could never be the option C beneficiary because they had a record of the court order and also of the divorce agreement. But needless to say, they still did not change his option. We know that. And so this case goes forward because on the form, she is still listed as the option C beneficiary. So Mrs. Jump filed an appeal with DALA regarding this option C beneficiary issue. Now, one thing to keep in mind or to remember about how the whole option process works is that the option is not chosen until retirement. And at retirement, you select one of three retirement options. Option A, and I'm going to simplify these and not use much math in them because I don't understand how all the calculations are done. That's what we have the actuarial unit for. But option A pays a lifetime benefit which ceases upon the member's death, and it amounts to the highest monthly payment. The option B is a slightly reduced payment, which allows for named beneficiary to be paid any amount remaining in the member's annuity account at the member's death. So typically, if the member dies 3 years after retirement, there will still be money left in the annuity account. If the member dies 20 years after retirement, there probably will be nothing left in the annuity account because the benefit, your retirement allowance, which is made up of annuity and pension amount, you will have exhausted the annuity amount by that point. In an option C, it pays a lifetime benefit to the member and then a reduced benefit to the named beneficiary upon the member's death. Now, in an option B situation, you can name anyone or any entity. So you can name a charitable trust as the beneficiary under option B. But under option C, there is a specific list of beneficiaries, including mothers, fathers, sisters, brothers, spouses, and ex-spouses, and children. Once you name the option C benefit is calculated and is a reduced in amount because it is calculated based on the member's age and also the beneficiary's age. And as the magistrate points out, those who select option C may not change their beneficiary once they have retired. Unlike the provisions applicable to option B, which expressly permit the change of a beneficiary from time to time as desired by the member, even after retirement, no such provision is applicable to option C. The statute is clear, and sound policy underlies this rule. Although the benefits under the three options are initially calculated to pay out equivalent sums over the retirement period, the manner in which the sums are calculated varies. Unlike the benefits provided pursuant to option A and B, benefits paid pursuant to C are determined by actuarial calculations based on the ages of both member and beneficiary. Were a member permitted to change a beneficiary after the date of retirement and after such calculations had been set, the actuarial soundness of the system could in fact be put at risk. Now, the board argued a couple of different things as to why they felt they could not pay Beverly Jump as the option C beneficiary. The first being that the separation agreement had a waiver of all rights to retirement or pension allowances. And they cited to 4 cases that talked about the situation where someone in their divorce agreed to waive their right to a benefit. But the magistrate was not persuaded by those cases because they weren't applicable, according to the magistrate, because they dealt with people that were changing beneficiaries pursuant to the context of option B. And therefore, since option B allows for post-retirement changes, then a settlement agreement or a divorce settlement could change a beneficiary for purposes of option B. However, this was an option C case, and as the magistrate has already pointed out in the decision, you can't change an option C beneficiary after the fact. The board also felt that it was obligated to enforce the assignment or waiver contained in the separation agreement under the Mangiacotti case. Now, the Mangiacotti case is a case from 30 plus years ago in which it was determined that separation agreements, divorce agreements, can in fact act as an assignment under section 19 of chapter 32 of part of a pension of a member. So the board felt that they needed to enforce this separation agreement under the same terms as they would any other divorce agreement. However, the magistrate rejected this argument because there was no assignment of benefits in the divorce agreement. In fact, the waiver was a waiver of benefits. but not an assignment of any particular payment. And it was a private agreement between Mr. and Mrs. Jump that did not involve the retirement board. As the retirement board was not a party to the agreement, they were not bound by the agreement. As such, the valid option C selection form designated Beverly Jump as the beneficiary was still in force, and she was entitled to the benefit. This case is currently on appeal to CRAB by the state board. The next case is the Parker versus Bristol County Retirement System. This involves Richard Parker, who was employed as a laborer with the town of Mansfield Highway Department from 1987 in May until November of 2013. Over the course of his employment, he suffered a number of workplace injuries, and the facts section of the case is very detailed as to when and all the different injuries. But it's only necessary to say that he injured his lower back in 2006, 2007, and again in 2010. He was out of work for 6 months following the 2010 injury, but did return to work to full duty. He then again injured his back on February 9th of 2013 when he fell on the ice while using a snowblower. After both the 2010 and 2013 injury, Mr. Parker underwent physical therapy and had injections. He was initially approved for workers' comp, but after the 2013 injury, but those benefits ceased in 2014. He was diagnosed with mild disc bulges and other spinal issues. He was also diagnosed with left hip arthritis, and he was evaluated by an independent medical exam in connection with his workers' comp case. That orthopedist felt that his arthritis was not related to his work injury. It was simply a degenerative condition and not in any way related to the actual back injury that he suffered in 2013 or 2010. And that his back problems were more likely related to his hip problem rather than the actual fall in 2013. On September 30th, 2015, so 2 years after he's been out of work, Mr. Parker applied for ADR due to left hip and low back injuries, listing the 2010 and 2013 incidents in his application. He was examined by 3 medical panel members individually. Dr. Rosenthal found that the injury was an aggravation of his previous 2010 injury, and thus he answered yes, yes, yes. Dr. Goss found that he was not disabled by the 2010 or 2013 injury, as they were both soft tissue injuries that should have healed within 4 to 6 weeks. He felt that the pain described may be a progression of his mild degenerative disc disease and his arthritis, which pre-existed his 2010 and 2000 injuries, so he answered no to the disability question in general. And the third doctor found that he was disabled, that it was permanent, but he didn't find causation. He felt that he suffered from a degenerative disease that were exacerbated by his 2010 and 2013 injuries, but they did not cause an aggravation of the underlying conditions. Now, Dr. Narius kindly provided everyone with his own definition of the word exacerbation and aggravation. He stated that an exacerbation is a temporary increase in symptoms of a pre-existing condition, while an aggravation is an increase in symptoms with accompanying structural damage. He ruled that this could not be an aggravation because there was no change in his MRIs or in his any other medical tests following the injuries from his pre-injury state. So he considered this to be the progression of his pre-existing condition that was not aggravated by the injuries. So the Bristol County Retirement Board denied Mr. Parker because he didn't have a positive medical panel. He had 1 yes, 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 and 1 no, and 1 yes, yes, no. Keep in mind, the medical panel must certify that a member is mentally or physically incapacitated from further duty, that such incapacity is likely to be permanent, and the disability is such as might be the natural and proximate result of the accident or hazard undergone. If one of these 3 questions is answered in the negative by a majority of the panel, the board has no discretion. They must deny the application. Now, I have to put a caveat here that in the presumption situation, the board does have authority on causation for override issues, but on a general disability, they cannot override a negative medical panel. If there is a negative panel, then a member must show that the panel has either applied an erroneous standard or failed to follow the proper procedure, or they must show that the certificate is just plainly wrong. In this appeal, Mr. Parker objected to Dr. Narius' determination as to causation, but did not object to Dr. Goss' determination that Mr. Parker was not even disabled. He objected to Dr. Narius because Dr. Narius, as we mentioned a minute ago, offered a definitive opinion on causation rather than answering whether his disability might be the natural and proximate result of the injury sustained or has undergone. This is an important distinction, as the appeals court has held that when a medical panel expresses only an unqualified opinion that a work injury did not cause an applicant's disability, without expressing an opinion as to whether the injury might have caused a disability, the panel's opinion is inadequate. They have stated that the panel has no statutory authority to express an unqualified negative opinion as to causation, and such an opinion, if expressed, is a nullity. This is because local board is entitled to know whether, in the opinion of the panel, there is a medical possibility that the causal relation exists. Absent such information, the local board lacks medical information that, with non-medical facts presented to the board, could provide the basis for the decision of the local board on the question of causation. The medical panel report on causation is evidence to be used by the board in determining, but they can also use non-medical evidence and other evidence gathered through their investigation and through hearing to determine the causation issue, even if the panel does in fact find causation. The magistrate, however, finds that Dr. Narius' opinion was in fact proper, even though he expressed a stated opinion of causation. And he explains this because Dr. Narius explains his view that the underlying condition is what caused the disability, not the workplace injury. Not only was the fact that he stated there was no medical possibility in 2010, 2012 injuries caused the disability problematic, but his description of the definition of exacerbation as opposed to aggravation was specifically addressed by the magistrate. This is the first time I've ever seen a doctor use a definition for exacerbation and aggravation to require noticeable physical damage or structural damage for an aggravation to be true. The magistrate specifically states that there is no question that an aggravation of a pre-existing condition to the point of total and permanent disability can be sufficient to establish the causation needed to prove eligibility. DALA has approved ADRs in the past where an aggravation caused permanent pain without particular structural damage. The magistrate finds that this definition issue would be problematic if Dr. Narius had relied on it, but it is not, as the doctor explained that his opinion was clear that the injuries were an exacerbation and that Mr. Parker's long-term pain is caused by the underlying condition, not the injuries suffered in 2010 or 2013. So the appeal, his appeal was denied, and the denial by the board was affirmed. The next case is Gorman versus the Plymouth County Retirement Board. Mr. Gorman, Stephen Gorman, was a police officer for the town of Hampton from July 1st of 1995 until June 20th of 2013. And Mr. Gorman came to work in the police department with a history of medical problems and injuries from his teenage years, apparently as a skier. Might argue he wasn't particularly good at it because he consistently dislocated his shoulder while skiing, and he further injured it again in 1989, well before he started work in 1995. He had surgery to repair his shoulder before he became an employee of Hanson in 1995, and by all accounts, he was fully recovered by the time he was hired in 1995. He claims that he was injured multiple times in his time as a police officer in Hanson. There were at least 3 injuries prior to 2002 in which he completed injury reports. And that's going to be one of the basically the focal point of this case is the injury report requirement. Because from 1995 to 2002, whenever he was injured, he in fact filled out an injury report. But for some reason, after 2002, he never filed another injury report. And none were in his file filed by anyone else. And he claimed that this was because a new police chief was hired and a new executive officer was appointed in 2001. And apparently, the policy, though not changed in writing, became that an officer, when injured, would notify the executive officer verbally, and that the executive officer was responsible for completing the injury statement. In November of 2007, he claims to have injured his shoulder, neck, and back while executing a search warrant. Apparently, he slammed into a door to open it with his shoulder. He claims that he reported the injury to the executive officer, but no report was filed, and the arrest report does not list any officer injuries. In April of 2008, he had herniated disc surgery, and in January 2009, he was examined for right shoulder pain. He had physical therapy, but then he ultimately had to have surgery in April of 2009 on that right shoulder. He had another shoulder procedure 4 months later in November of 2009, and then 1 month later because he developed an infection at the surgical site and had to have a revision surgery done. He did not return to full duty until May of 2010. He worked from May 2010 until April 2011. In August of 2011, he had another right shoulder surgery and was out of work until January of 2012. On November 2nd, 2012, about 11 months after he returned to work, he was placed on administrative leave pending the results of an investigation into his conduct on the job. On May 28, 2013, the department formally accused him of dereliction in duty in connection with a number of incidents in which it was alleged that he engaged in conduct unbecoming a police officer. Mr. Gorman and the town entered into negotiations to try to settle this issue, and they entered into a confidential settlement agreement in which he agreed to resign effective June 30th, 2013, and the town agreed not to oppose his ADR application. This right there is clearly a red flag to anyone that does the retirement statute and does any disability reviews, because you cannot use a settlement agreement or an employment agreement to settle an employment dispute in terms of the disability. Gorman applied for disability on June 17, 2013. Now remember, he hasn't been working since sometime in November of 2012 when he was first placed on administrative leave. He claimed that he was disabled as a result of numerous work-related orthopedic injuries to his shoulder and lower back. He described the incidents as effectuating arrests, serving warrants, and ramming through the door on 2 occasions with his right shoulder. He does not list specific dates of injuries for any of these incidents, or even specific injuries or specific job duties. He just listed them generally as effectuating arrests and serving warrants. He stated he ceased to be able to perform his duties on 11/1/12, the day before he was placed on administrative leave. Now, interestingly, in this case, there's actually 2 employer statements, and the employer in both reports that the officer was absent in 2009, 10, and 11 for non-duty related injuries. They're very specific that it's non-duty related. There's no listed work-related injuries, and the only difference between the 2 statements is that one notes that he filed for ADR in the wake of a personnel action, and the other simply states that he resigned effective June 30th, 2013. He was examined by 3 doctors, all of which answered yes, yes, yes. However, none of the 3 actually referenced a specific work injury, but somehow they still managed to answer yes on causation. The board approved the ADR application in April of 2015, and in May, PERAC remanded it for the first time, saying there was no injury reports included with the application, and no medical panelist mentioned any specific injury, and it wasn't apparent that Gorman was disabled when he resigned, because again, remember, he resigned in June of 2013, but he hadn't been working since he was put on administrative leave in November of 12. Plymouth County resubmitted it to PERAC, and we remanded it for a second time on the same grounds. After that second remand, Plymouth County denied the application, and Mr. Gorman filed the current appeal. Typically, in an accidental disability case, the only injuries considered are that which occurred within the last 2 years prior to the filing of the application, unless there is written notice of a prior injury which was timely filed. In this case, there's no dispute that Officer Gorman is disabled or that it is permanent. The main dispute is whether he was injured in the performance of his duties, and secondarily, whether he was disabled at the time he resigned. The magistrate first deals with the injury report issue. Officer Gorman testified that when the new executive officer started in 2002, no injury reports were filed by the members, but rather it was the executive officer's duty to do them. The department's own policy, written policy, clearly, however, stated that members were to fill out the injury reports, but the magistrate determines that it appears the department did not follow its own policies. Also notes that they didn't follow the sick leave policy that was in place with regard to Officer Gorman, and he uses that as some extra evidence that they weren't following either of the policies. So the magistrate has to determine that some of these injury reports needed to be filed or should have been filed in order to get more injuries in the 2-year, other than just the 2-year time frame. Because if you remember, he retired or applied for retirement more than a year after the last injury listed. And so that meant that only 1 year of his employment was being looked at, because nothing that happened in the year after he left work would be able to be used. So the magistrate looks to section 7.3b, which requires the department head to notify the retirement board of an injury when he becomes aware of it. Specifically, that section provides the head of a department shall, within 15 days of the receipt of knowledge of a personal injury sustained by a member in his department as a result of in the performance of his duties, notify the board in writing of the time, place, cause, and nature of such injury. So it clearly establishes that the department head is responsible for notifying the retirement board. And the magistrate found that the testimony was credible, that the executive officer was aware of the injuries alleged by Officer Gorman, and that the department failed to file the proper notices, and thus Mr. Gorman was not limited to using just the last 2 years, but could go back farther for injuries to sustain his claim for disability. Though the injury report issue didn't bar Mr. Gorman's proceedings, the medical panel does not specify whether he was injured during a specific incident. In fact, some of the panel simply noted that he claims work injuries, and other doctors have noted work injuries in prior exams, but the panel was not aware of a specific injury. Essentially, the panel couldn't be relied upon for causation, so this matter was actually remanded back to the board to have a new medical panel scheduled. And in fact, the new medical panel took place, and he was approved for disability in February of 2019. The medical panel was specifically instructed to address whether or not the member was disabled at the time that he left work, and they determined that he was. The next case is Donatelli versus the State Board, and this is another disability case, and this deals with bona fide personnel actions. Ms. Donatelli worked at the Executive Office of Public Safety and Security Office of Grants and Research. She was there from 1993 until 2010. She was a form of administrative assistant responsible for various grant writing and tracking grant money for the Highway Department. She began experiencing depression in around 2001. She claimed that this depression began because she was dealing with one of her brothers who was going through some sort of disability himself, and that he was an abusive person, and so she was becoming depressed, and she sought treatment, and she became medicated. And according to her, she was doing relatively well on the medication until about 2005. This case involves a very extensive fact pattern regarding all of the time that Ms. Donatelli was out of work. She was on approved FMLA leaves multiple times between 2005 and 2010. She even had various leave provisions that basically left it open that she could take a certain number of days off per month as leave time. All she was required to do was notify the employer within a certain period of time that she was going to take those days off. She was also authorized to have a modified duty schedule, a modified time schedule. But apparently for this entire period, she failed to follow through and live up to the agreement regarding her FMLA leave. She would simply not show up and not notify the employer that she wasn't coming. She would show up late with no notification. Apparently, she started to have workplace performance issues, and she was cited multiple times for performance reviews. And those reviews also entailed various remedial plans to get her back on track, things that she had to do, tasks that she had to accomplish, supervision that she was going to receive in order to keep her on track and to get her back to a satisfactory performance level. And this went on for probably about 3 years, where she was over months getting these different amended policies and amended performance reviews and tasks loads. She felt that this was abuse by her employer, that her supervisors were singling her out and were criticizing her unfairly. They knew that she had this mental issue, this depression that stemmed from an outside activity, but now she claimed that it was getting worse and that her performance was directly affected by the treatment she was suffering. So in fall of 2010, she was actually hospitalized for over a week because of her depression and anxiety. She did not return to work after this hospitalization, and she filed for superannuation retirement in December of 2010. About a year later, in the end of October 2011, she applied for an accidental disability, alleging a number of harassing incidents and abusive behavior by her supervisors. It's important to note that no injury reports were ever filed for any of the incidents that she mentions in her application or the incidents that she mentions in her comments to the medical panel. She was, in fact, examined by a 3-person medical panel, 3 individual exams, and they all answered yes, yes, yes. They noted that she had a history of depression, but that it was possible that the behavior treatment she received from her supervisors might have aggravated her underlying psychological issue to the point of disability. The board denied her ADR in September 2013, finding that she had failed to meet her burden of proof regarding causation. Now, the issue for a member trying to retire under ADR, they must show permanent and disabling injuries that were sustained during the performance of their essential job duties. And they have to cite a specific incident or series of events, or that the injury is a product of hazard undergone that are not common to other professions. Psychological disabilities have been analyzed by looking at specific injurious events and general job hazards. There doesn't appear to be a dispute that Ms. Donatelli is disabled and that the disability is permanent. The only issue is causation. The first issue with Ms. Donatelli's case is that she had no injury reports. This means by law, as we mentioned in the previous case, she can only use incidents that occurred within 2 years of the date of her ADR, which effectively restricts her from October 31st, 2009 until October 31st of 2011, but she stopped working in December of 2010. So she's really only got about 1 year worth of work behavior that she can use towards her disability. Under the aggravation of a pre-existing condition standard, which is what she would have had to claim because it's clear that she had the depression and anxiety issue years prior to the alleged incident, those incidents can be relevant and treated as part of the underlying condition if they predate the 2-year requirement with no injury reports. But they can't actually show the aggravation to the point of a permanent disability. The second issue is that she has to show that the actions of her supervisors that caused her disability were not bona fide personnel actions. To the extent mental or emotional injuries are caused by bona fide personnel actions, they are not considered personal injuries sufficient to establish eligibility for ADR unless those actions amount to intentional infliction of emotional distress or harm. In order for conduct to rise to the level of intentional infliction of emotional distress, it has to be extreme and outrageous, beyond all possible bounds of decency, and utterly intolerable in a civilized community. So essentially, intentional infliction of emotional stress cannot be predicated on mere indignities, annoyances, or petty oppressions, or other trivialities. It has to be based on significant behavior. And as the applicant, Ms. Donatelli has the burden of proof to show that her psychological damage was the natural and proximate result of her mental or emotional disability that she suffered at work. There's an extensive record from performance reviews, emails, and letters from her supervisor showing that the agency attempted numerous times to accommodate her medical condition. She had multiple approved leaves, accommodated schedule, reduced duties, all of which were in an effort to address her performance. Her negative performance reviews, warnings, and suspensions were all bona fide personnel actions, and none of them rose to the level of intentional infliction of emotional distress. Thus, the board was proper in denying the ADR application. The next case is Turalyan versus Chelsea. This case involves having to show that you were disabled on the last day you performed work. And this may be the largest gap I've ever seen in a disability between the date of injury and the date when someone stops working and the date that they apply for disability. Ms. Turalyan began working for Chelsea Police Department as a senior clerk on July 18th, 1983. In 1983, a couple of months after she was hired, she injured her left elbow at work. And in 1984, she had surgery to correct that injury. She re-injured that elbow on the door of an airplane when she was vacationing in Florida in 1984 and had to have a second surgery in 1986 to repair that injury. On May 31st, 1989, she was injured at the Chelsea Police Department when she went to sit down. The chair rolled out from under her and she smashed her elbow, the same elbow that she'd injured 2 previous times, on the side of the table. She also injured her lower back, struck her head, and aggravated a previous jaw injury, which was not specified. She did, in fact, return to work 6 months later in January of 1990 on a part-time basis. But she still had trouble with the elbow, and she needed further surgery. So she left the job in May of 1990, about a week before she was scheduled to have her next surgical procedure, which she had done on May 16th of 1990. In September of 1990, she was still out of work, and she was depressed because she couldn't work, and it was suggested she seek psychiatric treatment. She did that. Apparently, she was also involved in a car accident in 1989, which was noted in her medical records all the way back in 1994. And in her medical records, it noted that the accident aggravated her symptoms of her original elbow injury. She went out on workers' comp in May of 1989, May 31st, for her elbow injury. And it seems she continued to be on some form of workers' comp until October of 2005, when her benefits were exhausted. The case is not very specific as to how much she was paid or how she was paid workers' comp for 25 years, or 15 years, I'm sorry. The findings of fact in this case make note of her continued treatment from 1990 all the way through 2000, with numerous references to her medical records and doctor's notation that she still had trouble with her elbow from the initial injury, and it was at a medical end result. So she's injured in 1989, she leaves work in 1990, and lo and behold, it's June of 2013, 24 years later, when she finally applies for disability. It takes about 3 years before she actually gets a medical panel appointed, which happened in January of 2016. And she gets seen by 3 individual doctors. 2 of them respond yes, 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 and the third was a flat no, saying she wasn't even disabled. The board sought clarification from the 2 positive panel members to address whether she was in fact disabled on her last day. One doctor specifically addresses this by noting that she had surgery after that injury, right after she left work, and that she continued to have problems with the elbow even after further treatment and further surgeries over the ensuing 20 years. The board denied her application on December 22nd, 2016, finding that it was based on insufficient medical evidence to substantiate the idea that she was permanently disabled in 1990 when she stopped working. The third medical panel doctor actually said that he could not answer the question of whether she was disabled back in 1990 because too long had passed since that injury. The magistrate very clearly lays out the standard for ADR and the role of the medical panel and retirement board. The panel answers the questions on disability permanence and causation, and remember that it's such as might be the natural and proximate result of the accident or hazard undergone as the causation standard. The purpose of the medical panel examination and certificate is to vest in the medical panel the responsibility for determining medical questions, which are beyond the common knowledge and experience of members of the local retirement system. While the majority of the panel in this case found causation, that is not conclusive of the ultimate fact, but can be used as some evidence of causation. The board may override an affirmative finding on causation based on all the other information that they received throughout the process. The board denied the application, but the magistrate awarded ADR benefits because he determined that there was sufficient evidence to show that the May '89 injury was disabling, and she was disabled when she last left work in 1990 because she was already scheduled for surgery on the elbow for the week after she stopped working. The magistrate notes that there are medical records from the time of injury showing the symptoms that she suffered from, and that the majority panel relied upon in determining that her present disability was in fact a continuation of the disability she was suffering at the time she left work in 1990. The next case is Perry Doherty versus the state, so another state case. And this involves John Doherty, who was an HVAC industrial instructor at MCI Norfolk, beginning in 1998. In 2012, in October, he fell from the roof at MCI Norfolk while working on an HVAC unit and sustained injuries to his head, neck, back, shoulder, and knees. He suffered a concussion and herniated disc. He also suffered from post-concussion syndrome, memory impairment, blurred vision, headaches, depression, anxiety, and sleep disorder. He didn't return to work following these injuries, and he developed personality changes. He became withdrawn, irritable, depressed, and his PTSD from some childhood trauma became exacerbated. He had a history of alcohol abuse and addiction, but he'd been sober for a number of years prior to his injury. Following his injury, he again began abusing alcohol and also abusing prescription opioids, specifically Oxy. In January of 2013, he sought psychological treatment following a suicide attempt. In October of 2013, he was diagnosed with cervical spine stenosis, and he had surgery to treat his herniated discs. He continued following this, apparently to abuse alcohol and the prescription painkillers that he was prescribed following his surgery, and he died on November 13, 2013 from acute intoxication due to the combined effects of ethanol and oxycodone. This was a result of his chronic substance abuse. His widow, Miss Perry Doherty, filed an application for Section 9 accidental death benefits in 2014. Section 9 benefits are available when a retirement board finds that a member in service died as the natural and proximate result of a personal injury sustained or hazard undergone as a result of and while in the performance of his duties. The board requested that PARACA appoint a medical doctor to review, a medical panel doctor to review his posthumous medical records. And we appointed a doctor who determined that his death was caused by acute intoxication due to the combined effects of ethanol and oxycodone, and that the injury that he sustained was the natural and proximate result of his death, or that his death, phrased in another way, was the natural and proximate result of his injuries. Because he noted that Mr. Doherty was functioning well prior to his fall, and that as a result of this injury, he developed significant changes in personality, and he developed this chronic pain, and he attempted to cope with the pain through the use of substances. So the board approved the Section 9 benefit, but in 2017, Ms. Perry Doherty came back and applied for a Section 100 benefit. Now, Section 100 is a killed in the line of duty benefit that is available to certain public safety employees, and it amounts to a $300 payment to the family of the deceased public safety employee who, while in the performance of his duties and the result of an incident, accident, or violence, was killed or sustained injuries which were the direct and proximate cause of his death. The public safety employee definition specifically includes corrections officers, which he was, but Mr. Doherty did not die immediately from the fall he sustained in 2012. In order to be eligible for the Section 100 benefit, the widow must show that the workplace injury was the direct and proximate cause of his death. This is a more stringent standard than the Section 9, which requires that the death be the natural and proximate result of the personal injury sustained. While an accident or injury that arises as a consequence of workplace accident may qualify for an accidental death benefit, a line of duty death benefit must be directly brought about by the workplace accident or incident in question. The magistrate found that Mr. Doherty did not die as a direct result of his injuries, but rather from acute intoxication due to ethanol and oxycodone. Proximate cause is that which is in a continuous sequence, unbroken by any new cause, produces an event, and without which the event would not have occurred. In this case, Mr. Doherty's substance abuse was the intervening cause of his death, which interrupted the chain of events leading from his workplace injury to his death. And thus, it was appropriate for the board to deny the Section 100A benefit. I have two cases left to discuss, the Caton versus the State Retirement Board and the Newton Retirement Board versus State. I'm going to talk about these two cases in a combined fashion because the facts of both cases are not really particularly relevant. They're in the presentation to discuss a relatively recent issue that has been coming up since Chapter 176 of the Act of 2011. If you recall, in 2011, the statute was changed to basically create two retirement systems. You have the pre-April 2nd, 2012 folks and the post-April 2nd, 2012 folks. And they have different retirement calculations, but they also have some different provisions dealing with group classification. Anyone hired after April 2nd, 2012 and becomes a member of the system after that date is required to prorate creditable service based on their group classification at the time the employment was rendered. However, prior to April 2012, those employees have the option of prorating. So for the vast majority of people, this will not be an issue because they might have been a Group 4 police officer for their entire career, or they may have been a Group 1 person for their entire career, and so there is no need for any prorating. Now, a pre-2012 hire has the option of prorating, and they're not required to do it. So you can have a situation where a member spends 25 years in Group 1, and the last 5 years they work in a Group 4 position. A pre-2012 person can retire. If they are leaving employment and retiring from the Group 4 position, their entire benefit is calculated on Group 4. However, if the reverse was true and their first 5 years were in Group 4 and their last 25 were in Group 1, they would want to prorate, because you would get a slightly better benefit by prorating those 5 years as a Group 4 time rather than a Group 1 time and retiring under Group 1. So the Caton case involves an issue where Mr. Caton was a member of the State Retirement Board, but he had originally been part of the Barnstable County Retirement System, and he held a number of positions dealing with the public safety network. He was dealt with radio technicians, senior radio technicians. He was a network administrator at one point. and he believed a bunch of this time should be calculated as Group 2, and he wanted to prorate his creditable service when he went to retire, and he wanted a number of his earlier career time to be Group 2. And he also had technically Group 4 time, because while he was employed in Barnstable County with, eventually with the Sheriff's Department, he was also a call firefighter in one of the towns in Barnstable County. And at the time that he was a call fireman in the 90s, Barnstable County had a retirement board reg that allowed those people to be members of the system. So he was a member of the system, and he made contributions on the time that he was paid for being a call. He was never, in fact, appointed to the full-time fire department anywhere in Barnstable County or in any department anywhere as a full-time fireman. So normally the 4.2b provision for call volunteer fire service of 5 years credible service would not be applicable, but because the board had the reg allowing him creditable service and allowing him membership for a period of time, then he was in fact getting credible service for some of his Group 4 time as a call fireman, just not at the 5 years of free service or 5 years of full-time creditable service. So he also wanted that time prorated. There was an issue because the sheriffs all became members of the state system by virtue of it taking over, and the state, he asked the state to prorate his time at various jobs. He had like 5 different job titles, and the board denied him Group 2 time for all of his time. They also denied him Group 4 time for the call firefighter time because they argued he was already getting a full year of credible service by virtue of his full-time employment, and so he already got full credible service for that year, so he couldn't be getting any extra credible service for his service as a call firefighter. So the case the appeal happens on whether or not he should have been in Group 2. He loses that case because the magistrate is pretty clear that essentially the statute is very specific as to who is Group 2, and it all comes down to this definition of fire alarm signal operator and maintenance repairman. And since he never actually had those titles, even though he may have performed some of the duties, it still does not qualify him for group status because, and this is a unique situation because his time was he was in the county or state system at the time, and that municipal signal maintenance repairman is very specific that you have to be employed by a municipality, not a county. And his time was always employed as a county system, and not just a member of a county system, but his employment was through a county agency. So he was not eligible for that. Now, one of the other issues that comes up in this case, and also why the Newton case is in here, is this issue of group classification and when and who decides what group classification a certain period of service falls under. In the Newton Retirement Board case, this case was actually presented at a previous cases of interest when it was a Dalla decision. And in that case, Ms. Layton wanted to be classified in a higher group for some time that she spent when she was a member of the state retirement system. She actually was retiring from the Newton Retirement Board, and because of prorating, Newton said to the state, you need to tell us what her service with you, what group it was in, because she says that it was in Group 2 and she's in Group 1 with us, so she's eligible to prorate that time if it is in fact Group 2. The state board said no, they wouldn't even give them a group classification because the member wasn't a member of state anymore, she wasn't retiring from state, and they do not prorate service until the time of retirement, and they don't assign a group classification until the time of retirement. So Newton went to Dalla, and Dalla said, no, the statute is clear in 3.2G that upon hiring, the board shall classify each member in one of the following groups, Groups 1, 2, 3, or 4. and that they stated that the state board was required to classify everyone when they were hired. And not only that, but when someone retires from another jurisdiction, they are responsible for classifying the credible service that was earned while a member of the state system. This went on to be appealed to CRAB, and CRAB issued the decision that's mentioned in your packet. And that decision, they sort of watered it down slightly, and they said that the state doesn't have to classify everyone on the date they're hired or every time their job changes. But they are the entity that is responsible for classifying and assigning a classification to the time period when a member goes and retires from another system. Namely, the reason for this is because the previous board, in this case the state, will be liable for the 3/8C reimbursement, and the prior board will have more familiarity with the employers and job positions under its purview than the second retirement system where the member is retiring from. So they just have to classify each employee upon hire, not upon hire, but when it's requested by another board, and they must classify the prior service for that other board. They must also do this classification if they have a member that's retiring from their own system, and this will become more relevant in the future for anyone that was a April 2nd, 2012 hire. They will be required to prorate that time, and so the board is going to need to adopt some sort of policy in order to do this, I imagine, because they're going to have thousands of people in the next 20 years starting to retire with only post-2012 time where they will have to be prorated. And there obviously is within the state so many individuals that do switch groups. That concludes the presentation on the cases of interest that we have for you today. I am going to attempt to see if there are any questions. How do I make this bigger? If you have any questions, you can enter them in the chat box.
Go to the top.
Yeah, how do you make that bigger? I can't read it. Just having a little technical difficulties. We don't usually do this, and so I'm not sure how to work some of the computer stuff. Okay, so we have one question. And the first question deals with the issue of the waiver of your retirement allowance in the over-earning situation, where the question is asked, how about if the waiver is not for a 91 situation? How about if the retiree is looking to qualify for fuel assistance and requests a waiver each year? I'm going to be honest, I do not know the answer to that question. I've never heard of that as something that's been done, but we can look into it and try to get back. That actually appears to be the only question we've gotten. So if anyone has any question, you can please submit them, and we'll stay here for a couple of minutes.
Well, Elena wants a copy of the printout. That'll be on the website, actually.
Yeah, so it looks like someone is looking for a printout or PDF of the slideshow. We'll have the communications unit post this onto our website, and then it can be downloaded that way or printed out from our website. It'll probably take a couple days, probably just after Thanksgiving before we get that up. I know that some of them are already out for the holiday, so. I just, that Natasha Dunker, our communications director, has addressed, and that the presentation will be on the website, and the recording of this webinar will actually be available next week. Well, if there are no further questions, I want to thank everyone for participating, and I hope you enjoyed the presentation. I believe, I'm tooting my own horn here and Ken's horn, but this may be the highest attended webinar we've ever conducted at PERAC, so thank you for that. If there are no further questions, we will sign off. Thank you.